Good afternoon. I'm Bob Wright, and it's my pleasure to welcome you to the Michigan ADR case law update, hearing the latest from former ADR section chair Lee Hornberger. Lee, without further ado, I'm turning it over to you.
We will be doing a review of Michigan mediation and arbitration appellate cases since October of last year. In the chat, there is a link to a bigger review that includes 3 or 4 more recent cases and goes back to 2008. So if you want to go to that link, you'll get a bigger review. As I talk, I will be talking about MSAs. MSAs are mediated settlement agreements. I would suggest, if you have the materials in front of you, that you put them away. This will be more fun if you're not reading anything. Just have a paper and pencil, and as I cover the cases, I will give you the page number in the smaller review where you can go to the pages. Eventually, in this afternoon, we'll be discussing 3 important Supreme Court cases involving ADR. Number 1 will be Tyler versus Finland. Tyler versus Finland involves confidentiality and mediation. The ADR section filed an amicus brief. The decisions on page 8, Ed Pappas and Phil DeRosier wrote the ADR section amicus brief in the Tyler case. The second case is Lyshon versus Morse. Lyshon versus Morse involves mandatory arbitration of a sexual harassment type case. It's on pages 2 and 3 of the outline. The third Supreme Court related case is Poelman versus Poelman. The Poelman case is on pages 8 and 9 of the handout. This involved a domestic relations mediation, which was allegedly done without the domestic violence protocol. The family law section and the ADR section filed amicus briefs in Poelman. Bob Wright wrote the ADR section amicus brief. During the past year, the Court of Appeals upheld 16 arbitration awards in the 16 cases where arbitration awards were at stake. In addition, the Court of Appeals affirmed or enforced 7 MSAs in the 8 cases where MSA enforcements were at stake. Let's go to Tyler versus Finling on page 8 of the outline. In Tyler, the Supreme Court protected mediation confidentiality. Tyler versus Finling was a defamation case. This was a defamation case arising from statements made by one attorney acting as a receiver to another attorney before they were going to meet in person with the mediator at the start of a court-ordered mediation. This was a conversation between 2 attorneys in the plaintiff's room while the parties were waiting for the mediation session to start. Unknown to Mr. Finling, who ended up being the defendant in this defamation case, the other attorney in that room was secretly tape recording the conversation between the other attorney and Mr. Finling. Mr. Finling made some allegedly defamatory statements concerning Mr. Tyler, the ultimate plaintiff in this defamation case. That tape recording ultimately made its way to Mr. Tyler. Mr. Tyler sued Mr. Finling for defamation. The circuit court said that those statements in that room waiting for the mediation to start were protected by MCR 2.412B2, confidentiality for mediation. The circuit court agreed with Mr. Finling these were confidential communications. The Court of Appeals reversed. The Court of Appeals reversed and said that Mr. Finling was not a mediation party. The mediation hadn't started yet, and therefore these statements were not confidential under the mediation rules. This then went on an application for leave to appeal to the Supreme Court. In partial response to the Ed Pappas and Phil DeRosier written ADR section amicus brief, the Supreme Court unanimously, without oral argument, reversed the Court of Appeals. The Supreme Court held the statements were MCR 2.412 mediation communications, and they were confidential. The Supreme Court indicated that mediation communications broadly include statements that occur during the mediation process and statements that were made for the purposes of preparing for mediation. We do have the question, though, if this was a pre-suit mediation, no lawsuit involved, and therefore MCR 2.412 did not apply. That's why we should have, whether we're in a court's lawsuit or not, a confidentiality agreement signed by everybody. The scale standards of conduct for mediators provides that the mediator should include a statement concerning obligations of confidentiality in a written agreement to mediate. The next case we're going to review is the Pohlman versus Pohlman case on pages 8 and 9 of the outline. Pohlman is where ultimately the Supreme Court denied leave to appeal in what is the domestic violence protocol case. In a split decision, the Court of Appeals enforced a circuit court enforcement of a domestic relations MSA, even though allegedly, no domestic violence protocol had been done. The Court of Appeals two-person vote held that because the plaintiff did not show she was prejudiced by the mediator's alleged failure to screen for domestic violence, that the non-compliance, according to the COA majority, with MCR 3.216 and MCL 600.1035 was harmless. Judge Gleicher in the Court of Appeals dissented. Judge Gleicher held that the circuit court was obligated to hold a hearing to determine whether the wife was coerced into the settlement. The Judge Gleicher dissent indicated that only by evaluating the proposed evidence can the circuit court make an informed decision of whether relief was warranted. There were applications for leave to appeal to the Court of Appeals. And of course, we have the Bob Wright ADR section amicus brief and a family law section amicus brief in favor of granting leave to appeal, and therefore implicitly that the Court of Appeals would be reversed. Instead of ruling on the leave to appeal initially, the Supreme Court ordered the circuit court to do an evidentiary hearing and submit findings to the Supreme Court concerning the wife's allegation that her signature on the MSA was involuntary. This then went back to the circuit court. The circuit court held a hearing. the circuit court issued a 42-page decision and found that the mediator had complied with the mediator's obligation to screen for domestic violence. Pursuant to the order of the court, this finding, these 42 pages, will then filed with the Supreme Court. After the Supreme Court received the circuit court findings, the Supreme Court denied leave to appeal. There's some issues here. One issue is, and I could be wrong, what the Supreme Court should have done after it got the findings was grant the leave to appeal and vacate the Court of Appeals decision. What we have here with a leave appeal denied is a Court of Appeals two-person decision that kind of says, if you don't, it's okay if you don't do the protocol, as long as the change of heart person cannot show that it was harmful. The Court of Appeals decision should have simply been vacated instead of just leave to appeal denied. The Pullman case has some other lessons, and these all showed up in the hearing in front of the circuit court judge. Number one, these are some ideas. If you're the mediator, when you do the protocol, send an email to the two attorneys saying, I've done the protocol. Create a paper trail of the protocol. And that way, when someone starts saying you didn't do the protocol, there's a paper trail letting everyone know you did it. Number two, in the hearing in the Pullman case, the change of heart person argued that she never saw her attorney's mediation summary until the mediation, that she had no input into the writing of her mediation summary. This became a difficult position once the attorney produced the email chat between him and her drafting the mediation summary. In addition, again in Pullman, food surfaced. Pullman in the hearing argued, I did not have food. The mediator testified she did have food. We have not seen the wording of the mediated settlement agreement, but again, Pullman reminds us that we should put bulletproof language in the MSA. This is a final and binding MSA. I can go to court. I might get more. I might get less. No one has forced me to do this. And again, we have the issue of wouldn't we be better off if the Supreme Court had granted leave and then vacated the Court of Appeals majority decision. We're now going to segue. There's no Michigan COA published decisions during this period concerning mediation, none. We do have, though, Court of Appeals unpublished decisions. Let's go to Jones-LaSalle versus Barrow Management on page 9 of the outline. This is not an MSA case. This is a settlement case, but not an MSA case. In this case, the parties apparently agreed via email traffic to a settlement agreement. And they agreed there would be a release, but ultimately they could not agree on the wording of the release. And since that gap existed, the circuit court held and the Court of Appeals affirmed that not agreeing on the wording of the release defeated the settlement agreement. So what we have here is the lack of definition of the word release in this non-MSA case killed the settlement agreement. There's two things to remember. Number one, if this had been a comprehensive MSA that simply said mutual crisscross releases, my guess is it might have gone the other way. And number two, this is a lesson that maybe in the MSA, we should provide some post-settlement procedure in case there's an argument over what the MSA means. On page 9 is CIGL Properties versus Renovation Services. This was a debt collection situation. There was a long mediation, and it ended up in a settlement. And the settlement said the debtor will pay X dollars a month, no matter what. If there's a payment missed, no matter what, that there will be acceleration and entry of judgment. The debtor misses a payment. And we're now at the circuit court hearing to enter judgment. And when the circuit court asked what happened, the debtor explained he had had surgery, and had forgot to send the check. The circuit court expressed dismay and said, I'm not going to enter a judgment when someone has only missed one payment and they can't help it, and refused to enter the judgment. The Court of Appeals disagreed and reversed the circuit court. This could have gone the other way maybe, but in this case, the Court of Appeals reversed the circuit court. Zeibel versus Michael Fisher Builders is on page 10 of the outline. This involves another ex parte motion for judgment based on an MSA agreement. In the MSA, everybody agreed that the calculation of damages would be determined by a particular inspection company's calculation. And whatever that calculation was, the debtor would pay it, and the debtor waived any argument and waived the right to appeal to the entry of judgment. The inspection company did the calculation. The debtor didn't like that calculation. The debtor then argued against the entry of judgment and appealed the entry of judgment. The Court of Appeals said, no, you agreed in the MSA that you would not appeal the judgment if it were entered, and therefore you have waived your right to appeal. Drake versus Auto Club Insurance on page 10 is a no-fault auto negligence case. It's a change of heart case where the Court of Appeals says we don't do change of hearts and enforced the MSA. On page 10 is Cowell versus Cowell. This is a domestic relations case where the Court of Appeals partially affirmed a judgment of divorce incorporating the MSA. Two things are in Cowell versus Cowell. Number one, this involved real estate. It involved a long MSA with property stuff in it and beneficiary language in it. When the MSA was incorporated into the judgment of divorce, it wasn't incorporated accurately. They either didn't use copy and paste or they retyped it, but different property definitions got deviated. And because of this, the Court of Appeals agreed that the MSA had not been successfully incorporated into the judgment of divorce, and the judgment of divorce was vacated. So the lesson from Cowell versus Cowell is to be careful when we're paraphrasing an MSA into a JOD. On page 10, we have the Court of Appeals reversing a default judgment. This is now called LLC versus Condom Sense. Condom Sense. The debtor is a guarantor. He's a debtor because he's an alleged guarantor. He's in a lawsuit. He fails to appear at mediation and a status conference because there's been a change of attorneys. The circuit court, I guess you would default him. The circuit court defaults him for the failure to appeal. And he files an application to set aside the default judgment. And the circuit court refused to set aside the default judgment. The Court of Appeals, to a certain degree, agreed with the circuit court. The Court of Appeals said, yes, it was not an abuse of discretion for the circuit court to conclude that the debtor had failed to establish good cause. But in this very unique situation, a lower good cause was needed because not having a signed guarantee would have been an absolute defense. And for some reason, the creditor was never able to come up with the signed guarantee, so the Court of Appeals set aside the default judgment. We're going to do a couple condo cases. These are fun cases. On page 11, in Neff versus Chapel Hill Condo Association, this is the basement flooding case. If you have nothing to do one afternoon, go listen to the oral argument in Neff versus Chapel Hill Condo Association. This is a basement flooding case that turns into Marbury versus Madison. It just blows up. And so we're in the circuit court, and the circuit court orders the plaintiff to go to mediation. And the plaintiff argued, you can't order me to mediation. That deprives me of my right to a jury trial. On the second day of mediation, the plaintiff threatened to sue the mediator, and she left the mediation. And then the plaintiff refused to pay the mediator. The defendant's saying, we want the case dismissed. We want the case dismissed because she's not complying with the mediation order. The circuit court says, no, not quite so fast. I'm going to order the plaintiff to pay the mediator's fee and post a bond. If she does that, the case can go forward and I won't dismiss her. The plaintiff refuses to post the bond. She refuses to pay the mediator, and the case is dismissed. The Court of Appeals affirms. The tip from this case is, number one, do not disobey a mediation order. And number two, be nice to the mediator. The next case, which is on page 11 of the outline, is another condo case. This is March versus Lambert. March versus Lambert. This is the carpet case. It's a condo. We have the upstairs condo. We have the downstairs condo. The upstairs condo has a carpet floor. The upstairs people remove the carpet floor. Now they have a wood floor, and it makes all kinds of noise that the downstairs people don't like. There's then a lawsuit. This is the carpet case lawsuit, and there's a mediation. During the mediation, they come up with an MSA, a mediated settlement agreement, that says the upstairs people will put in carpeting, and the carpeting will be attached to the floor. The upstairs people put carpeting in. It's snug as a rug, but it is not nailed. It is not attached to the floor. And the downstairs people bring an enforcement action and say it has to be attached. The circuit court said, no, attached doesn't mean attached. And the Court of Appeals agreed that the upstairs people could do the best they could do to get a carpet that was snug. So March versus Lambert teaches us that even if we want something to be attached, What can you say? In Toole versus Stowell on page 11, the Court of Appeals affirmed the enforcement of a probate MSA on page 11. And these are the everyday things that can happen that are unexpected. We have a mediation going on, and there's an argument, a discussion. This is shuttle diplomacy, and there's a discussion over the value of the company. And the issue arises, has the company filed income tax returns? The CPA is there in the other room. The CPA fills out an affidavit or a handwritten document and signs it for the mediator that says, I wrote the tax returns, signed CPA. They take that back to the other side, the mediator does, shuttle diplomacy, somehow that settles the case. Later, the settling party discovers that there were that the tax returns were not filed. So they bring in action to set aside the MSA because there was a misrepresentation about the tax returns. The circuit court said no. The Court of Appeals said no. They both said you relied on a statement that said the tax returns had been prepared. That statement did not say the tax returns had been filed, and therefore there was no misrepresentation concerning the MSA. On page 11 of the outline is the Olabeek PC versus Crehan case. Again, this is another oral argument case that's fun to read. It's a lawsuit for attorney fees and involves a lot of issues. At the tail end of the Court of Appeals non-published decision, the Court of Appeals said, defendant argued there was an agreement by the parties to mediation, and in light of this non-fulfilled agreement to have mediation, which never happened, that the circuit court did not have authority to grant summary disposition. It doesn't say whether this was an alleged written agreement or an alleged oral agreement. The Court of Appeals said, though, that the defendant had provided no case law in support of this argument, and therefore they weren't going to consider it. What is an important argument? And by accident, we know there's solid Texas case that says if there's a written ADR procedure that says a condition precedent to arbitration or a condition precedent to court proceedings is mediation, then you have to do the mediation. This is not in the outline, but it is in the link. And one of the Texas cases is 238 SW 3rd 574. 238 SW 3rd 574. We're now going to segue to arbitration. And we're going to discuss Lyshan versus Morse. We discussed Lyshan versus Morse a year ago, but a lot has happened in Lyshan since then. In Lyshan versus Morse on pages 2 to 3 of the handout, the Supreme Court remanded to the circuit courts for reconsideration of whether the sexual assault claims were subject to arbitration. This is a case where back in history, and I'll assume it's just one case, makes it easier. The circuit court had found for the defendant and ordered arbitration. The Court of Appeals in a split decision had found for the plaintiff and said, go to court, no arbitration. And then the Supreme Court on July 20th of this year in a split decision remanded and said reconsider circuit court whether there should be arbitration or court proceeding. In the vacated Lyshon versus Morse case, the split decision, the Court of Appeals held that the sexual harassment claim was not covered by the arbitration provision in the employee handbook. This was because the arbitration provision limited the scope of arbitration to claims related to plaintiff's employment, claims related to plaintiff's employment. And according to the COA majority decision, because sexual assault cannot be related to employment, the arbitration provision is inapplicable. This is the Court of Appeals majority decision where the Court of Appeals, as we can recall, stuck its neck out and said, quote, central to our conclusion is the strong public policy that no individual should be forced to arbitrate his or her claims of sexual assault, end quote. The O'Brien Court of Appeals dissent said that the parties agreed to arbitrate any claim for discriminatory conduct, and the claims arguably fell within the scope of the arbitration agreement. The Supreme Court majority vote reversed this. 4 for the majority, 2 for the dissent, 1, I think it would be Justice Welch, had not been there during the oral argument a year ago and didn't get a vote. The Supreme Court majority reviewed whether the claims fell within the scope of the wording relative to employment. And the Supreme Court said, hey, surprise, in Michigan, when we're reviewing whether something's relative to employment, we're going to follow the 11th Circuit 2011 case of Doe versus Princess Cruise Lines. And the citation of all this is on page 2 and 3 of my outline. And the Supreme Court quotes the Doe Princess Cruise Lines case. If the employer had wanted a broader arbitration provision, it should have left the scope at, quote, any and all disputes whatsoever, end quote, instead of a limitation that narrowed the scope to only disputes related to the employment. And the Supreme Court majority said, since the Circuit Court did not have the benefit of this Princess Cruise Lines framing, we're going to vacate the Court of Appeals and remand to the Circuit Court for reconsideration in light of that. Now, it's interesting, no one on the Supreme Court even mentioned to discuss the, quote, central to conclusion is the strong public policy that a sexual assault case cannot go to arbitration. That kind of got left in the dust. There were 2 dissenters in the Supreme Court case. They held that the court must interpret the contract to determine whether the parties meant for the plaintiff's present claims to be arbitrated. They said it's inappropriate to go back to some circuit court decision from a non-Michigan court and create a new standard. And to a large degree, the Supreme Court dissent would have not reversed the Court of Appeals. Now, I don't know if I should go there or not, but it's laying there on the table. We have 2 people in dissent. That's 2 of a particular viewpoint. We have 4 people in the majority opinion, of which 1 usually goes the other way. And then we have Justice Welch, who did not participate because she beat an incumbent justice of the other party in the election. So if Justice Welch had not gotten on the court, it would not have been a 2-person dissent, it would have been a 3-person dissent. And if one of the justices in the 4-person majority had not flipped from her usual group, this decision would have gone the other way. It might not be relevant, but it shows elections have consequences. Let's go to page 3 of the outline. And this is another employment arbitration case that shows that the wording of the arbitration provision is crucial. This is Barkai versus VHS of Michigan. Barkai is an employee. Barkai gets fired, and Barkai says, my firing violated the Whistleblower Protection Act, and Barkai sues in circuit court. The employer argued this is subject to an arbitration clause that mandates arbitration. Barkai says Whistleblower Protection Act is not discrimination, it's Whistleblower Protection Act. And the circuit court agrees and says no arbitration. The Court of Appeals reverses and says Whistleblower Protection Act claims were covered by the arbitration provision. That's broad language, and therefore it has to go to arbitration. On page 4 of the outline is Webb versus Fidelity Brokerage. This is an interesting case. Webb worked for GM. In a buyout or something, Webb left GM. A lot of GM stock was then transferred to Fidelity Brokerage in the name of Webb. That stock went south, mortgage, bankruptcies and whatnot, became worth basically zero. Webb then sued Fidelity Brokerage and said, hey, you violated your ERISA responsibilities to me, and I have an ERISA action. The Court of Appeals, affirming the circuit court, said no, this is not an ERISA case. This was a normal brokerage case. And if the brokerage contract has an arbitration clause, you then have to go to arbitration. The decision doesn't say it, but this would probably be FINRA arbitration. In page 4, Advanced Integration Technology versus Recap Industry Assets, we see something that's popping up that's very interesting. This whole case is interesting. The arbitrator granted a motion for summary disposition. I repeat, the arbitrator granted a motion for summary disposition. In response to that, the losing party filed a motion to vacate. The circuit court, instead of ruling on the motion to vacate, the circuit court remanded the award to the arbitrator for clarification, which arguably gives the moving part, the winning party, a second bite of the apple in a way. The arbitrator issued a clarified award. The circuit court confirmed the clarified award. The Court of Appeals affirmed the circuit court's confirmation of the clarified award. The plaintiffs are arguing the circuit court should not have sent the case to the arbitrator for clarification, or should have vacated the award. The circuit court and the Court of Appeals is saying, yeah, but MCL 691.1700 paren 4 close paren allows the circuit court to remand, to order an award back to the arbitrator to be clarified. The Court of Appeals ruled that the circuit court was not required to vacate the award on the basis it was unclear or appeared the arbitrator may have erred. An option the circuit court had was to send the case back to the arbitrator for clarification. On page 4, we have Sandella and Associates versus Sieber. In this case, we have the defendant couple. Darcy and Jonathan are the defendant couple, and they own a house, and the husband has a comprehensive construction contract with the plaintiff to do repairs on the house. The wife is living in the house. She co-owns the house. Why she wasn't asked to sign that contract, I don't know. There's an arbitration clause in that construction contract. As the work is being performed, the wife is involved. She orally agrees to everything that everyone does, and she participates in the decisions concerning the work. Something goes south, there's a court case, it goes to arbitration, the husband and wife largely lose, and the arbitrator holds the wife and the husband, but the wife jointly and severally liable. And the wife says, "You can't hold me liable. I didn't sign the contract that contained the arbitration clause." The circuit court said, "But you were deeply involved in the whole thing. You knew what was going on. I'm going to confirm the award." And the Court of Appeals affirmed. On page 4 is the Centennial Home Group versus Smith case. This is where the COA affirmed the confirmation of an award. There was an award. It's a well-written decision. If you're an advocate and you have to write a brief to confirm an award, you may not want to cite this unpublished decision, but if you go there, there's good language in it citing the Michigan law. But the argument was the retaining award done properly? And the construction company is saying too much money was put in the retaining award, and it's a big argument over retaining award construction. And the Court of Appeals held it's up to the arbitrator. We're not going to second guess the arbitrator. On page 5, in Whelan Corporation versus New Genetics, there was an issue where the circuit court, there was a mishmash of, there was a contractor and there were subcontractors. There was a lawsuit against both. The circuit court did not order any arbitration because it says all the claims should be in one forum and only one of the parties had signed the arbitration provision. The Court of Appeals disagreed. The Court of Appeals held that you go to the one party that has signed the arbitration provision, they arbitrate. You go to the party that has not signed it, and they don't arbitrate. In page 5, we have a repeat of what we saw earlier. Masculine Trust versus Atkinson. This was in the probate court, and the Court of Appeals held that the probate court did not err when it referred the case back to the arbitrator for correction or clarification under 691.17004C. On page 5 is Lewis versus IDS Property Casualty Insurance. This is an automobile negligence payout case. The arbitrator issued an award, a one-word award, a one-sentence award for $50,000. $50,000. This is the truth, folks. No one read the award. It sat there for a while because everyone knew this wasn't a $50,000 case. This was a 25 plus 15 equals $40,000 case. But the parties never read the $50,000 award, which was a mathematical mistake. Eventually, the defendant issued months later a payout check for $40,000. The plaintiff then looks at the $40,000 payout check and says, hey, I'm going to go read the award, $50,000. You owe me $10,000 more dollars. They then contact the arbitrator. The arbitrator said, oh, my notes say 25 plus 15 is 40. I made a mistake, the arbitrator says. The plaintiff says, tough. The time to file a motion to amend or correct the award has gone by. There is no time period to confirm an award, and therefore it should be confirmed for $50,000. The circuit court says that's right. You should have read the award. It's beyond the time period to amend or correct, and therefore I'm going to confirm the award, and the Court of Appeals affirms. This is the same thing that happened in Prospect Funding Holdings versus Reifman Law Firm on page 5. The arbitrator awarded the plaintiff damages. The circuit court confirmed the award. The Court of Appeals affirmed the confirmation of the award. And again, the 90-day period that the losing party had to file to amend the award and expired. Page 5 is a fantastic, wonderful case. This is where the Court of Appeals affirms the refusal to attack an own award. This is Asmore Construction Company versus AFR Enterprise. This is application for leave still pending. This involved a business dispute involving 2 arbitration hearings from 10 years ago concerning a project from 20 years ago. There was an allegation that the arbitrator was bribed. 10 years ago, the losing party filed a circuit court complaint asking for a hearing. The circuit court denied that motion 10 years ago. They then appealed 10 years ago and goofed up their appeal procedurally. And the Court of Appeals 10 years ago dismissed the appeal. Now, years later, the plaintiffs are again appealing the circuit court's denial of the motion for relief from judgment. But they have new evidence. Now, the arbitrator in this case was not an attorney. The arbitrator was a mutual friend who they hired to be the arbitrator. So in today's appeal, the losing party brings forth an affidavit signed by the arbitrator. This is an affidavit signed by the arbitrator. And the arbitrator says in the affidavit, I was bribed. And if I hadn't been bribed, I would have gone the other way and ruled for the other party. And the circuit court held, and the Court of Appeals held, that the motion for relief from judgment is untimely. If you'd kept your case alive 10 years ago, you might have uncovered this bribery 10 years ago, but we don't want to hear about it now. But it's a fun little case. We're going to change ball games now. We're going to labor arbitration on page 6. This is ASME versus Wayne County Airport. This is fun stuff. We have a grievance. We have an arbitration. We have briefing. We have an award. The arbitrator followed one of the CBA articles in the grievance, but ignored the arguably applicable Article 34. Apparently, everyone argued they should win under 34, and the arbitrator issued an award that didn't even mention Article 34. He mentioned some other article. The circuit court confirmed the award, recognizing the limited scope of review of labor awards. The Court of Appeals reversed. According to the Court of Appeals, the labor arbitrator should never have considered Article 34, which was not in the briefs of anybody, and therefore it has to go back to the same arbitrator for a new opinion. The arbitrator is free to consider both articles, but he has to consider both. This decision from the Court of Appeals, I think, could have gone either way. In Davidson versus Davidson, this is a Domestic Relations Arbitration Act award on page 6. We have a domestic relations case going on. While it's going on, there's an agreement and an order to arbitrate. This would be a stipulated agreement, and with domestic relations, there's a lot of Miranda rights that have to be read back and forth. So it's very formal. The court case is then dismissed. The court case is dismissed. And one of the parties later argues that when you dismiss the court case, the arbitration agreement died with it. And the Court of Appeals held no. The dismissal of the court case did not vacate the agreement to arbitrate. On page 7 is Roman versus Ameriprise Insurance. In this case, the appellant argued that the award should be vacated because I, the client, never signed the arbitration agreement. Only my attorney signed the arbitration agreement. And the Court of Appeals held so. The attorney can bind the client and enter into a binding arbitration agreement on behalf of the client, MCR 2507, paren G. Page 7 is Wilson versus Lewis Buildings. This is a building arbitration case. And after the arbitration is over, and after the plaintiff loses the arbitration, this is in a small town. It's kind of like a Hartman versus Hartman situation, but we don't go to Florida, so it's not maybe quite like Hartman versus Hartman. The losing person from the arbitration argues that the arbitrator and the defense attorney were friends, that they had worked on legal matters together, and at least twice a week in this town, they had lunch together, but other attorneys were there. The circuit court denied the motion to vacate, and the Court of Appeals affirmed. The applicable MCL in the Uniform Arbitration Act would be 691.1962. I'm not saying this was an incorrect decision, but arguably it could have gone the other way.
Lee, you have 2 minutes.
Thank you. Thank you. So what we've seen is, number one, remember I have that nice link in the chat, which is the expanded update, which covers some additional recent cases and also goes all the way back to 2008. We've seen, number one, in Tyler, that confidentiality in mediation is good in Michigan. We see in Leishan versus Morse, the arbitration sexual harassment case, that the wording of the agreement to arbitrate is crucial. And we've seen in Pullman versus Pullman, even though it may not be good, you have an unpublished decision that doesn't give deference to the protocol that should be given to the protocol. And hence, I would submit that ADR is alive and well in Michigan. Thank you.
Thanks, Lee. Terrific as always. This has been a great year for ADR cases and for the ADR section involvement in some of those important cases. The link to the next session is in chat. So thanks, everybody. You may leave. Again, thank you. Lee.
Thank you. Have a good day.